Thank you very much, Honorable Mr. Speaker. There is a term that is coined generally when you fully support the pronouncements made in a court of appeal or any court. Namely, I concur, I think is a term. It is the term. I feel that at this point in time, I would like to concur completely with Mr. Anil Nandla. I do it when it is necessary, as is my prerogative. And indeed, as he enunciated in his inimitable style, with passion and verve, it is important that indeed a statement be made as to, as he mentioned finally in his approach to the discourse, as to why for such a long time this piece of legislation stood the test of time, notwithstanding a lot of people being critical of it. And I could recall criticisms coming since the time I was a member of the DPP's chambers, and that was from 1984 to 1989. I remembered lots of magistrates at the time, especially in matters dealing with the banned goods cases. Remember, there was a time when certain items were banned, and magistrates found people smuggling, and then they came to the conclusion that the matters should be discharged or dismissed. And not only that, some serious matters that ought to be sent to the Supreme Court for trial. You had a situation whereby the DPP would want to make the necessary committal to the High Court. And the evidence sometimes was in tremendous deficit. And you got the impression that, look, this magistrate was right not to commit the person. But there you had it, a DPP. And I remember some, Mr. Ramon, Mr. George Jackman, and I think later on Mr. Ian Chang, who would then, if they feel that it ought to be sent to the High Court for trial, they will send it under that Section 72. I want to state that indeed it had certain jurisprudential value, in the sense that when some of the DPPs found that the magistrate might be not too straight, or a shady magistrate that had released the person or discharged the person, there might be grounds then, if they look at the depositions and they found that indeed this is a case that ought to go up, and they look like they got some skullduggery here, that is where generally this power of the DPP came very valuable. And indeed, as a result of that, they will then do the order, ask and then commit to the High Court. Mr. Speaker, but notwithstanding all of that, there is this process that the law evolves. And it evolved in that way of whereby this provision, Section 72, was highly regarded because of the fact that certain judges of tremendous quality gave it an authority. And that set of judges dealt with the matter in a case very important. I think it was Williams. And the very important judges of that case comprised some of the most brilliant legal minds. Chancellor Haynes, Justice of Appeal Crane, and Justice of Appeal Messiah. And this matter came before them where they had to test the constitutionality of that Section 72. And for good reason at that point in time, and probably because of the advocacy of the lawyers then, they managed, because it was an extremely nice point, really good jurisprudential point, they decided that they are going to regard it as constitutional still. And the reason was given by Chancellor Haynes, and that reasoning was also redone by the president of the CCJ, Mr. Saunders, at page, I think it is paragraph 49 of the judgment. Because this excited a lot of constitutional law at the CCJ. Chancellor Haynes' response to that submission was unequivocal. I'm quoting from it. What the Chancellor expressed is more nuanced than the question as to constitutionality. The Chancellor had no doubt whatever that Section 72 is inconsistent with the right to a fair hearing guaranteed by the right to protection of the law. In his view, however, and this is the point I wish to make, the law was validated only because it was an existing law. And as such, its constitutionality was saved by the savings provision for existing law then found in Section 18 of the Constitution. In our new Constitution, it is now Article 152. So when DPPs used that power, and when the Court of Appeal recently held indeed, prior to this matter going to the CCJ, that indeed it is still constitutional, they were resting their case on very good authority via that Williams matter, and especially the judgments, erudite judgments, you might say, of Chancellor Haynes and, of course, Justice of Appeal Crane. And so because our Constitution makes provision for an existing law, which saves all the existing law prior to the Constitution coming into being, and this was one such law, I think they argued, or was argued before them, they then say that, okay, there is a certain element of it that might strike unconstitutionality, but because it was there prior to the Constitution and laws prior to the Constitution coming into being must be saved, otherwise we will not have a legal regime or a legal architecture, it is so saved. That is putting it very simplistically. And so this section was saved. And we had it right up to when the matter came in the Bishram's case. And in the Bishram's case, as was mentioned just now, by the learned Attorney General, it is important that this argument was taken to even a higher level, and I must congratulate the lawyers that made appearances in the CCJ that took this argument to that very high quality level. Mr. Darshan Ramdani, Queen's Counsel, and Sanjeev Dattadin, Dexter Todd, Arudranath Gosai. Not that Ms. Shalimar Haq and the rest of her team did anything badly. They maintained the precedent of the Williams case, but of course, the court then started this process of questioning the constitutionality of it for the very first time, right up to that point, where they then concluded that indeed it was unconstitutional. And of course, as mentioned, they themselves in the CCJ decided that this must be modified, and of course, they suggested a modification I am happy to see that substantially that modification has been implemented in this bill. I am also going to state that I am also impressed in the sense that the two other sections that deals with the issue of the DPP having a right to kind of overrule a magistrate, and the other two matters, the amendments to Section 78 and 79, which correctly have been called consequential amendments, have been done at today's date, so that at least we could get a complete overhaul to the extent of making that which was unconstitutional now being constitutional. The judiciary, in the sense of judges being given the power now to ensure that they deal with this matter of prima facie case rather than the DPP, I think is putting it and residing it in the proper place. And I totally agree too that it should not be ex parte. There is a natural justice principle that should remain for the accused in any serious matter where imprisonment and even hanging are the penalties, that they should be given that right to be heard. And so, although there might be a little variation from that which was suggested by the CCJ, I believe that that variation is commendable in the form that it has taken here by virtue of this bill. And so to that extent then, I want to also commend the bill for passage in this House. I remembered very many occasions, and not only whilst being a prosecutor in the DPP's chambers in those years, but also on the other side, the defense counsel. And you could remember the treason case, the Maikoni treason accused, and a lot of things being said there where no case submissions were made by the defense counsel at that point in time, Bernardo Santos, and it being overruled. And then, of course, a long time in jail, they came for trial, and of course the no case submission was upheld. Simply because if you had certain, evidence rather than what you call that which is taken as a deposition level, you could have avoided those lengthy incarcerations. And so there is an element of justice that I see forthcoming from the CCJ's rationalization and expounding. I see also the need to start thinking about those unconstitutional existing laws that might soon be challenged and impugned in our courts, not only this Section 77. And to that extent, then, it is a good precedent for the purposes of ensuring a greater entrenchment and enshrinement of fundamental rights, fundamental human rights, whether they be substantive rights or whether they be procedural rights. And in the context then of the bill coming here in accordance with that which the CCJ ruled, and also the consequential or the amendments in accordance with what the CCJ ruled, I could only concur with the AG at this point and support this bill completely. Thank you very much.